Before we turn to audience questions, I have a couple that I'd like to pose to our panel members. Paul, George expressed concerns about how agencies make their choices in terms of which models they're going to use, which data they're going to use, which documents they looked at, which ones they didn't look at, which algorithms they used. Are agencies required to discuss that in any way in their final rule, to tell people what they did and what they didn't do and why? And is that part of the judicial review process as well?
Yes, I think so, Alan. It just makes sense that if you've got to show, if you got to a place, you got to show how you got there. And I think an agency that does that really is an agency that will preserve itself from remand on review. Some agencies are better at it than others, but you do have to show a trail of logic to an outcome, and failing to do that is a jeopardy for you on appeal.
George, let me ask you this. In addition to data that are actually produced, there's a lot more stuff that's out there as part of the process. For example, the original proposal to a federal agency to do a study. There is the protocol that was developed. There are algorithms. There are models that were used by a grantee. Do those have to be made available to both scientific magazines and to agencies? And should they be made available? Or that is it possible to understand what Lynn Goldman said about some of the things that can be done with data without having more than just the numbers as you outlined?
Alan, that's a great question. I haven't thought about it. So it's sort of the question is, where do we draw the boundaries? Where is the edge of our circle when we're talking about data disclosure? When you look at, for example, journal requirements, they tend to be the things that were used in producing results. So they're going to be the raw data. They will include, many journals will require you to post your computer code. So that if you've got, whether it's an analytic code in SAS or if you write your own code to help do a particular model to get a result, you have to post that as well.
Does that have to go to, would that come under Shelby as part of data, or is that unclear?
You're the lawyer. I don't know.
Well, have you seen it asked for? Let me put it that way.
Certainly codes have been asked for. And perhaps, I don't know, Dan Greenbaum can talk about some of the challenges that we're running into with trying to reproduce data using codes that are sometimes proprietary. I mean, these computer programs are written by investigators and may or may not be widely available. But this question of going back to the proposal and such, I really don't know. I don't imagine that would be relevant, but I don't know.
Lynn.
I mean, speaking as an epidemiologist now, most of us believe that our questionnaires and protocols are fair game and that we do need to make them available when people want to see them. And there are times when if you don't see the questionnaire and understand exactly how the data are collected, that you really can't understand what the responses mean. And because, it's the art of epidemiology, depending on how you ask the question, you can get a very different answer. So, and depending on who you're asking as well. But I wanted to ask actually Paul a question. One of the things I noticed before, and you had it up on the slide again, is that one of the, some of the language that the administrative conference used about what investigators do when they are submitting data, to an agency. And the truth of the matter is that most of the time, university investigators aren't actually submitting data to the to regulatory agencies. There are many statutes now that require regulatory agencies to use best available data. It's set in different ways in different statutes, but where the agencies aren't simply supposed to use data that are submitted to them, but they're supposed to, do a data dragnet and find the best available data, whether they're data that the investigators want to submit or not. And I think a concern by investigators has been, well, I didn't do that research, for the purpose of a regulation. Now I'm being asked, to undertake the burden of doing all these special things, for a regulatory agency who didn't fund me, They might be investigators in other countries, not necessarily even U.S.-based, but that research could be the best available science, for a regulation. Just, your comment on that. What's the obligation of an investigator to a regulatory agency that perhaps, didn't fund them?
Thanks. If the question, these are investigators who aren't even contracting with the agency, who just happen to have work in the public domain?
Right. I mean,
Well, I don't.
An investigator in Norway who did a study, perhaps, that EPA decided was one of the best studies on a particular contaminant, needs to be included in an assessment. It's published in the scientific literature.
So I don't think you can subpoena the investigator in Norway and get his data.
Shelby doesn't apply, right?
No. But it does raise a bit of a conundrum for the agency, and this goes back to that use of the word considered, which we say anything the agency considers should be put in the record on review, right? Now, what is considering? And if you're doing, a proactive review of the scientific literature before you make a decision, and you see something in a Norwegian scientist's report, are you considering it? And if you are, then I guess maybe my answer would be you better make sure you got the whole picture before you consider it, so that if the scientist doesn't have, let's say, underlying codes available and other things, which means it cannot really be analyzed, then it probably shouldn't be considered. But I don't know how you force that beyond that.
Linda Birnbaum, Director, NIEHS. So we funded a great amount of epidemiological research, and I'll use the Norway example, where we may actually fund a small piece of an analysis of a piece of that data that has been collected by the Norwegian investigators. And it is often unclear to us, even given the Shelby Amendment, whether that data has to be provided upon a FOIA or not. I mean, our understanding, I think, is that if it is involved in rulemaking, and we funded part of it, but we didn't fund the data collection. What we funded might have been one little part of somebody analyzing the data. And I think it is certainly not crystal clear to us what our grantees have to make available in those situations.
Well, this just gets harder and harder, so, yeah.
And that's why I asked.
And,
this is a common occurrence.
I'm trying to give you all comfort. I feel as a, doctor of law that I should do that. But
There's no attorney-client privilege here, is there, Paul?
no. So these, George, maybe you can help me. You must have had this experience. You had to do this stuff.
No, well, and what I will say is this does also, Linda's question is great, because one of the things that it also identifies is a real concern in the scientific community that I know is going to be on the agenda later in the day. That is a question of doing the kind of, say, an epidemiologic study that Lynn Goldman alluded to, or that they might be supporting a small part of. It's an enormous effort to collect a large amount of data that, frankly, can be someone's career. You are going to be able to analyze that data and subparts of it, and do all kinds of interesting things for years and years and years. If you have to publish that data, make it available with your very first paper, it's a very hard thing for the scientific community to get comfortable with. And we encourage the junior faculty in our department, getting that support to go out and develop a cohort, is what they'll often talk about, is a huge career step, because this is going to be something that they're going to be able to build a career on. And if they have to reveal all of those data right away, that really changes that model that we've used. So there are really hard questions, not only about what part of the studies were funded, but also what part of the studies are disclosable in this kind of a setting.
Well, let me just, I'm sorry, go ahead.
Well, I was just going to say, I think that'll come back to some of the later discussions. But I do think, and I think, Paul, that you mentioned it earlier, the whole issue of PII being a potential exemption for certain things. And in lots of the data collection, in fact, you can scrub it as much as you want, and yet you're still going to be able to identify who the subject was that was being addressed. And
So-
it's a huge problem.
Yeah, but I just urge you to keep in mind the key distinction between data that must be submitted to support a rule in the context of a rulemaking, and then a DQA request or FOIA request, which are more general and may or may not involve the courts at all. So the enforcement issue is totally different, and maybe the questions are too.
So if I may shamelessly proceed as I did before, the question that George asked about what happens when you develop a data set and it becomes publicly available, and then you make one publication, that is precisely the issue we're going to talk about at our conference next week, and that as applied to state universities, and it doesn't have anything to do with submitting to an administrative agency. If it's there in the state university, whether you've published it or not, it's potentially subject, and it includes all sorts of things, including peer review comments as well. I believe this gentleman here is next.
My name is John Gardenier. I've had several decades of experience with the interface between the American Statistical Association and the American Association for Advancement of Science and the National Academies on issues of data. And my concern regards ACUS. Is it adequately connected with other scientific resources that relate to the same issue? And among those, I would highlight, of course, the board, the National Academy of Sciences Board on Research Data and Information. They have, for many decades, been the central focus for what are the laws and policies regarding handling of research data. And they have a lot of experience, both nationally and internationally. Now, they may not specifically deal with the issues that are hot button topics for ACUS at a given time, but their broad experience could certainly provide a potential resource to ACUS if there is some form of liaison or communication that allows interplay between the two. Second one that has come up just within the past 3 years, but is potentially even more important, is a new global community called the Research Data Alliance, which is dedicated to making certain that all useful scientific data and research is available globally, considering the north-south divide and the haves and have-nots among nations and so forth, as well as coming together with common standards for sharing of research data. Specifically, a huge issue is the metadata that is used to describe a communal data system and they cover all communities of science. So this is a rather important development that I'm trying to follow and can only do so much with, but ACUS should be aware of it also. The last thing I want to mention is, in addition to Nature and PLOS, within the past few weeks, Marcia McNutt, who is the editor of Science magazine, produced a blistering editorial on reproducibility of research and noted that recent studies that attempted to reproduce or replicate various rather important studies could not do so. And it sounds as if she's rather annoyed.
Thank you.
But
We don't have very much time,
okay,
and we've got a whole bunch of
we've
other
got to
questions here, so if you could bring
you've
your
got
question to a conclusion.
To do it properly, you have to have statistics involved as well as the underlying science.
So I would just say briefly, yes, thank you for those comments. We look for any help we can find, especially, as I said, before we did this recommendation, we had a meeting with the National Academy of Sciences, which was open. We try and hire consultants who are sensitive to these various issues, and we have liaison members, and maybe we should do that directly with the NAS and others, to make sure we're informed, because we do work under certain constraints, and we're not scientists, basically, as members of the conference.
Dr. Lamb.
Excuse me, can I ask everybody to please keep their questions short? I see already there's a problem, which is everybody is anticipating what's happening in several sessions down the road. So try to limit yourself, if you can, to the questions presented by our two panelists here.
With respect to the issue of data acquisition, two field-level issues are, one, if the agency is going to request data, they ought to have a budget that allows them to pay for the acquisition. That projects have been funded, the budgets no longer exist. Asking somebody to go there and find the data in the archives requires time and money. That's an important issue. A second thing is the issue of who owns the data wherever it is. Recognize that so many of the papers that we use was somebody's PhD dissertation. They're now in some other institution. They aren't interested in that area anymore. Either the professor has moved on to other things and trying to find out where the data is, who is in a position that they can even release the data. Those are critical field-level issues.
Thank you. That comes particularly important in the context of state universities when the question is, does the researcher own it or does the university own it, and what happens if there's a conflict? Another question to be taken up at our panel.
Hi, Ellen Silbergeld from Johns Hopkins. I would just like to assure this panel that no, you are not giving much comfort to practicing scientists. And in fact, the idea that my life is going to be regulated with all respect by lawyers is very frightening. I think there's some things you have not adequately defined. I just would urge this to be considered by the rest of the meeting. What do you mean by data?
No, that's just a question of how big is the circle and what things are in and what things are out, and that is a real challenge. Is it only the data on the specific study that's being relied upon? Is it something that's broader? And is it down? What level of detail is required?
Is it just numbers, or is it more than numbers?
Right. Well, but remember, a lot of these things, materials and methods are out there. That's not your question.
The question is at what level do you start calling something?
Could you go to the mic?
Oh.
Yeah. Could you go to the microphone and?
These really are not trivial questions. I didn't walk away because I know my good colleague, Dr. Domenici, is going to follow, and she's been through this. But this, you spend all your time arguing about the word consideration. We really need your consideration of what you mean by data. There is going into the laboratory thinking about something, there is starting to measure something, there is what people, trivially refer to without definition as raw data, then there is redacted data, there is analyzed data, group data. Do you want everything? You really need to think about that, good friends-in-law, more than the word consideration, or equal to the word consideration.
We'll try to answer that in just a second, but we'll take the last question because we only have 2 minutes left in the program.
This is Dan Greenbaum from the Health Effects Institute, and we'll probably get into that later on, too, because a lot of these administrative things, A110, et cetera, attempts to define that, but I agree with Ellen, it's an issue. I have, though, a legal question, and it comes partly from my running an institute, the Health Effects Institute, that, as George alluded to, has done a lot in this arena, but also from my having been Commissioner of Environmental Protection in the state of Massachusetts and having to wrestle with these questions, and having my decisions reviewed by courts, et cetera. And it goes back to Lynn's question, really. So there are two possible examples. One is that study in Norway. I'm going to go back to the study in Norway. And it is one of, a dozen studies that have found similar things, maybe some positive, some negative, but the agency is considering it as one of several. And then there is that study in Norway, which is one of 2 studies worldwide that has found an effect which the agency is trying to characterize and think about regulating. Is there a different legal standard there? Is there something, and if you're the agency, this is what I'm, because it's the agency decisions that are then going to drive, do we need to get the data for this, et cetera. How would a judge look at that, or should a judge look at those situations, and what is consideration in those 2 examples?
Well, I will speak as I'm not, but if I were a appellate judge, my answer would be to you, yeah, if it's one of two studies, then you have to have it, and you better, as the agency, you better well track it down and have it ready. If it's one of 10, you know, you explain why you didn't do it, but you don't need it, I think. And that's why you would use, you know, sort of degrees of logic as to how important it is to your particular decision. It's about the best answer I could give.
I think it would also be important as to whether there are any countervailing studies on the other side and what you're citing the study for. I mean, it's very context-specific, but as Paul said, sometimes you really need to go out and try to get the data, and if you can't get it, many statutes require you to use, as Lynn said before, the best scientific evidence available, and that may be the best available, and you may not be able to get the very, very best. George, you want to say?
I mean, just to add to that, I mean, I think other things I might challenge you guys to think about is, well, one, what is the seriousness of the outcome? You know, is this something that kills people or, you know, gives them a slight headache, you know? And so, but also, where was it published? The best journal in the world, the peer review, the quality of the peer review, and the judgment of the scientists about the quality of the study. But, you know, I think another thing to think about, when was it done? So there are many things that have been demonstrated in the environmental literature decades ago that you couldn't get published today. Benzene and leukemia, nobody's really doing seriously able to even study some of those, asbestos and lung cancer. The data for those are not available in raw form. They're on, you know, if they're available anywhere at all, they're probably in media that you can't read anymore, you can't utilize. And to say, well, I'm going to lop things off and only allow the use of data that you can actually acquire is kind of difficult to hear in that context.
Thank you. I see, if we had been in the Supreme Court, when Chief Justice Rehnquist was presiding, you would have been cut off in mid-syllable, not even mid-sentence. But we'll have to cut off the discussion now. I'll be around for much of the day today, and I have a feeling there may be some more legal questions come up from time to time. Paul, thank you. George, thank you. And